Welcome to Based in Fact, a true crime podcast. We're your hosts, Lisa O'Brien and Kyle Evans, and we have Rick Mullenax of the Burn After Reading podcast joining us today for episode 9, State of Texas versus James Garfield Broadnax, part 2. In 2008, Broadnax and his cousin Demarius Cummings robbed and killed Stephen Swan and Matthew Butler in the parking lot of Butler's recording studio in Garland, Texas. Shortly after his arrest, Broadnax, in interviews with local media, confessed to shooting and killing Stephen and Matthew. In part 2, we'll look at Broadnax's subsequent state post-conviction claims, including the false claims made by Cummings ahead of Broadnax's execution on April 30th, 2026. And happy July 5th. Good afternoon.
Happy post 4th of July.
Yeah, good afternoon. Happy 5th of July.
5th of July, the day after. A friend of mine has a sticker, and it's Thomas Jefferson, and it's like something like July 3rd, 1776. You mean that's due tomorrow? So, which reminds me of my high school days. All right. Well, I have a storm moving through, and it's been wreaking havoc with my internet. So we're going to go ahead and get this started real quick. And hopefully we'll be able to get through it, before my internet shits the bed again. The victims in the case are Stephen Steve Swan. He was born July 13th, 1981 in Dallas County, Texas. His parents are Craig Swan and Jean Swan. His siblings are Deborah Swan Burkhart and Michael Swan. He was a singer, songwriter, and sound engineer at Zion Gate Records. He had just learned, just prior to his murder, that his cancer, whatever type of cancer that had been, had gone into remission, and his cause of death was multiple gunshot wounds. Then Matthew Garrett Butler Sr., he was born November 3rd, 1979. His parents are Michael and Teresa Butler. He was a musician, songwriter, producer at Zion Gate Records. He also owned Zion Gate Records. He was married to Jamie Butler. They had only been married about 3 years, and they had 2 children, Matthew Garrett Butler Jr. and Michaela Grace Butler, and both of them were under 3 years of age when their father was killed. His cause of death was also multiple gunshot wounds. The perpetrator, or one of the perpetrators in this case, was James Garfield Broadnax. He was born October 30th, 1988 in Monterey County, California. His parents were James Garfield Broadnax on his birth certificate. His birth father was an airman or someone else in the U.S. Air Force, or working with the U.S. Air Force at the time he was conceived, and with whom his mother had an affair. And his mother was Audrey Eason Broadnax Maxwell Kelly. He had 4 siblings: Aaron, Nakia Marie, Karen, and Michael. He married Tiana Kresnicki on April 14th, 2026, and y'all keep that date in mind because it's going to play a part later in the show. He was a high school dropout. He probably had antisocial personality disorder, a form of psychopathy, and he was aggressive. The person that people met after he had been incarcerated for 10, 15, 20, 17 years wasn't that person, but that's the person he was at the time of the murders. He had a possession of marijuana charge. He also had a burglary charge and 2 assault charges in custody. So, and then his accomplice was Demarius Dwight Cummings, born October 11th, 1988. His victims were Matthew Garrett Butler Sr. and Stephen Lewis Steve Swan, and he was executed on April 30th, 2026 in Huntsville, Texas. Spoiler alert. That's how this is going to end.
Yeah, not going to end well for him.
But it's interesting the path that it took
Right.
through the last couple years. Of course, this crime occurred on June 19th, 2008. The victims were Matthew Garrett Butler Sr. and Stephen Lewis Steve Swan. The crime occurred at 810 West State Street in Garland, Texas, and that is in Dallas County. Matthew Butler was a musician, singer, songwriter who started his own Christian music label, Zion Gate Records, in 2005. Matt credited his faith with helping him overcome and be healed from severe bipolar disorder. He was also a compassionate person who would give up his own possessions to someone in need. His friend Steve Swan was also a musician, singer, songwriter, and sound engineer. Steve had recently been declared in remission after battling cancer. Steve was a problem solver, he was gifted, and he had a wry sense of humor. At sometime after midnight on June 19, 2008, Matt and Steve left the studio and encountered Broadnax and his cousins Cummings in the building's parking lot. The cousins had ridden a bus to downtown Dallas to hit a lick, which is a slang for robbery. In preparation for that, Cummings used an aunt's AK-47 to borrow a 9mm Browning pistol. Shortly after arriving downtown, I have to turn on a light. They decided to take the DART train to Garland because, according to interviews given by Broadnax, that's where all the rich white folks stay at. The train had stopped running by the time Broadnax and Cummings approached Matt and Steve in the parking lot. The group initially engaged in conversation about the music business. When they finished talking, Broadnax and Cummings turned as if to leave. It was at that point that Broadnax turned back and asked for a cigarette. When Steve reached into his pocket to get cigarettes and a lighter, Broadnax shot him. Broadnax then shot Matt, who fell to the ground and tried to get up. Broadnax shot Matt again, then shot Matt and Steve each in the head to make sure that they were dead. Cummings searched Steve's pockets, retrieving $2 and the keys to Steve's tan 1995 Crown Victoria. Because Cummings thought Matt might still be alive, he refused to search his pockets. The pair left Steve and Matt lying in the parking lot and returned to Dallas in Steve's stolen car. Matt and Steve's bodies were found sometime after 1 a.m. by a man riding his bicycle home from work. That man rode to the nearest fire station to get help, and the firefighters determined that Matt and Steve had been dead for some time and notified police. Later that day, Broadnax bragged to family about hitting a lick and showed off Steve's driver's license. When their cousin Arnisha saw the news report about the murder, she contacted police. She gave a brief statement over the phone, then met with police for a formal interview. She recounted the cousin's possession of the stolen car and debit and credit cards belonging to Steve Swan. When her cousin said they were going to use the cards at an ATM, she reminded them that they would need PIN numbers to do that. So these guys weren't even smart.
Yeah,
their
not
aunt
exactly going to be the president of the Garland Mensa chapter.
Their aunt Alice also recounted Broadnax's bragging about hitting a lick in Garland in the stolen vehicle. She responded to their bragging by telling them both to leave. In addition to providing the license plate of the vehicle to police, Aunt Alice retrieved Steve's stolen credit cards when they were thrown from the car as Broadnax and Cummings drove away. Another family friend corroborated Aunt Alice's statement. Cummings and Broadnax asked a man in the apartment complex to hold the gun used in the murders and lied when they told him the gun was clean. After pawning a toolbox that belonged to Steve, they switched the license plates on the car and left Dallas for Texarkana, Texas. That night at around 8 p.m., Broadnax, who didn't have a license, was driving the car in a rough neighborhood in Texarkana. When a routine check showed that the license plate on the car came back to a Cadillac, not a Ford, the police had probable cause for a traffic stop and pulled Broadnax, Cummings, and Lonnie Harris over. Each of the three occupants had warrants, so they were arrested during the stop. When the car came up stolen out of Garland, Texarkana PD contacted Garland PD, who issued arrest warrants for Broadnax, Cummings, and Harris. Evidence found in the vehicle included 2 black hooded jackets, a mask, a pair of gloves, a white rag, 2 white towels with red stains, Broadnax's Social Security card and birth certificate, and 2 notebooks containing lyrics about robberies and murders. When questioned by police, Cummings admitted to being involved in the robbery and murders and implicated Broadnax. The third suspect, Harris, was questioned, confirmed to have been in Texarkana, which is about 180 miles away, on June 19th, and so he was released. Cummings also directed police to John Calhoun, the man holding the murder weapon. Calhoun turned the gun over to police, and on June 23, 2008, he advised police that the 2 men he'd seen on TV were the men who gave him the gun. Cummings also admitted to pawning Steve's property, and police were able to recover the toolbox and obtained video footage from the pawn shop showing Broadnax and Cummings A, driving up in the stolen vehicle, and B, inside the pawn shop during the transaction. The clerk also advised investigators that Cummings and Broadnax had attempted to pawn a red toolbox with engraved tools, but because the tools were engraved with the initials SS, the pawn shop declined to buy them. Finally, the clerk told investigators that he'd examined the tools, which were in the trunk of the stolen Crown Victoria. DNA evidence included DNA recovered from the left side of the handgun, which was consistent with Swan's DNA. DNA recovered from inside Steve's pockets, which was consistent with Cummings' DNA. Blood found on a pair of Nike tennis shoes belonging to Broadnax, which was consistent with Butler's blood. And DNA obtained from a swab of the handgun's trigger was consistent with both Broadnax and Cummings. And that's also going to be important to remember later. Broadnax and Cummings were both arrested on June 20th, 2008. Or actually, probably it may have been June 19th, 2008. They were arrested in Texarkana and then transferred to Garland. That was about the 20th, and then on the 21st, they were transferred from Garland to Dallas County Jail. Their first appearances were in Dallas County on June 21st, 2008, facing charges of capital murder for multiple persons, and that was initially assigned a docket number, but later on the case was transferred to a different docket because they only pursued charges as to Steve. On June 23rd, Broadnax and Cummings were interviewed by Channel 11, Stephen Antonio Pickett, Channel 5, Alan Goldberg, and Channel 4, Sean Rabb. Broadnax initially denied any knowledge of or involvement in the robbery and murders. Later, he described in detail how he and Cummings approached Matt and Steve, talked for a bit, pretended to leave, stopped, and asked for a cigarette, and then shot Matt and Steve multiple times to make sure they were dead. He admitted to getting $2 in the robbery and driving off in Steve's stolen car. Broadnax made it clear he was the one who had the gun and fired all of the shots that night. Broadnax expressed no remorse, claiming he would laugh at Matthew's wife and say fuck him, to the Butler and Swan families. He also promised he'd kill again if sentenced to life in prison. Cummings was also interviewed, and he expressed remorse for the murders and denied killing either of the victims. He admitted to the intent to rob the victims and contributing to their deaths. Cummings also admitted that he told Broadnax he might have to pop them a few times. He also led police to evidence linking Broadnax and Cummings to the murders. Bradley K. Lawler was appointed to Broadnax on June 24, 2008 as one of his attorneys. He also had been represented on arraignment by Lydia Brandt, whose name will come up, who represented him in post-conviction. On that same date, Lawler sent a request to the jail instructing them not to let Broadnax speak to the media or law enforcement. But he had already spoken to the media, so the horses were out of the barn by that time. On June 3rd, 2008, he was officially charged with capital murder of multiple persons in the earlier docket. And then a true bill indictment came down on September 8, 2008 from a grand jury for the capital murder of Steve Swan, and that's when the case was transferred to the final docket number, which was F08-24667-Y, and that was in the Criminal District Court 7 in Dallas County, Texas, before the Honorable Michael Snipes. At his first appearance, he pled not guilty, and his bail was set at $1 million. Jury voir dire took place between May 26, 2009 and July 20th, 2009. And apparently in Dallas County, they bring in the panel and they go through challenges for cause and peremptory challenges and pick the jury during that process. And that takes place a couple months before the first day of trial even takes place. It's like a separate
proceeding.
A separate process, which is usually not how it's done. Usually it takes place the first day of trial, voir dire begins, and the jury is picked, and then the trial begins. So that was held, and then on a hearings were held on some of the challenges to evidence on July 30th, August 4th, and August 6th. And all of these challenges were overruled with the exception of one Batson challenge that was granted and a juror was reinstated. And then the state's motion to strike the jury array was denied. The August 10th is when the trial began. And I guess officially the trial begins with another plea of not guilty. The guilt innocence phase went from August 10th to August 12th. I've seen different days because I've seen the verdict come down on August 11th. But that's pretty much consistently August 12th. And then the punishment sentencing or punishment phase was August 12th to August 20th. And the punishment after guilt of capital murder, unanimous guilt of capital murder, was death. Broadnax was formally sentenced to death on August 21st, 2009. His direct appeal went to the Texas Court of Criminal Appeals because it was a death penalty case. That opinion was decided on December 14th, 2011, and his 56 points of error were overruled, and the judgment of the trial court was affirmed, as was the sentence. The mandate was issued for that case on January 9th, 2012. His conviction and sentence became final on October 1st, 2012, when a writ to the U.S. Supreme Court was denied. He also had additional writs to the U.S. Supreme Court.
Oh.
Were affirmed on October 31st, 2012. Yes, sir.
Oh, you're back. You cut out for just a quick second.
Dang it. What part cut out?
Oh, just like 5. It was really quick.
Okay. All right. Sorry about that. Texas versus Cummings, his conviction and sentence were affirmed on October 31st, 2012. Broadnax's state post-conviction claims, he had 2 claims. Or no, he actually had 1 claim. It was recommended for denial of relief in the trial court on September 17, 2014. And then on May 20th, 2015, the Texas Court of Criminal Appeals denied relief per curiam. Broadnax went on to federal habeas. Relief was denied on July 23rd, 2019. On February 8, 2021, a COA was denied, and the judgment of the district court was affirmed in part, and a petition for rehearing was denied on March 23rd, 2021. So now we go into his subsequent state post-conviction claims. And I decided to do this quasi-chronologically. So we're going to jump between the state post-conviction claims and the execution proceedings and back to state post-conviction. And some of the state post-conviction claims were, being pursued at the same time, so we're going to kind of jump back and forth. But hopefully, since it's chronological, it'll kind of make sense. The first one was in the Criminal District Court and the Texas Court of Criminal Appeals. That was assigned docket number WR08-24667-Y parentheses B. The judge was Judge Chika Anyam. And the case also was in the Texas Court of Criminal Appeals. The docket number was WR-81573-02. Because it's a subsequent post-conviction, it goes to the Court of Criminal Appeals, and then they decide whether to remand it for further development or to deny relief. Broadnax was represented by Camille M. Knight, Stephen C. Herzog, who was admitted pro hoc vice, Pietro Signoracci, who was also admitted pro hoc vice, and in this particular
Uh-oh, Lisa, we lost you again.
and this is the basis of the claim. The DA's office provided a jury spreadsheet and jury questionnaires with handwritten notations to Broadnax's counsel. He tried to pursue that as, quote, new evidence in federal court, and that was not successful. But it became the basis for this subsequent state claim. And then in 2021, the DA's office provided additional voir dire notes and work product to Broadnax's counsel. On August 12th, 2022, and well, let's go through. I think it was 2021. And Craig, Kyle, you're from that area.
Yep.
The Soros judicial reform DA was elected, and he started the post-conviction integrity unit.
Yeah. I mean,
Craig Watkins.
Yeah, he was basically a even a bad defense, barely literate defense attorney who was elected DA, and almost it seemed like somebody had played an April Fool's joke on the county. But fortunately, he was I think defeated the next term. But yeah, he was a terrible
Okay.
DA.
But wasn't and I may be confusing the DAs. At the time of the trial in 2009, that's the one I'm thinking of, I think. Craig Watkins.
Yeah, Craig Watkins is the guy who honestly was kind of. I think there was a big. I think that was the big kind of sweep of, kind of nationally, and he kind of got elected. I think everybody thought it was almost like a joke. He wasn't qualified. I don't. I'm blanking on the years. I'll have to do a quick
Okay.
Google search.
Yeah.
But yeah, Craig
But
Watkins is the guy who was.
and
Oh
he
wow,
was
I didn't realize that he passed away in 2023.
oh,
Yeah,
okay.
he was DA from 2007 to 15.
Okay, yeah. So he prosecuted Broadnax. He was the DA at the time Broadnax's
Yeah,
case was tried. Okay.
yeah.
So that's what people need to keep in mind. But anyway, so then
And he was the
even
first
more
African
liberal.
American. He was the first African American DA of Dallas County.
Okay. Yeah. He's also the one that Darley supporters thought was going to open the jail doors and let her out too.
Yes, exactly.
But that's another story. So then in the 2020s, an even more liberal DA, Cruzat, was it?
Yes, who just got defeated in this last election cycle by even a wackier one.
Oh
So
Lord.
this is just like, where they're electing the Nazi in Maine and all those crazies in New York. I mean, they're
Yeah.
taking a radical leftist is even being defeated by even a nuttier one.
Yeah. All right. So anyway, so back to this after that aside. There was a meeting on August 12th, 2022 between Herzog, Yeats, and Bolito, which may have been a prosecutor as well. And Broadnax's counsel, Herzog, was presenting a proposed first subsequent writ and Batson claims based on the spreadsheet disclosed during the federal habeas proceedings. On November, now there are some emails between them because I think this sets the story for the writ. So I think it's important to keep it in there. An email was sent from Yeats to Knight, Herzog, and Ananth, another of Broadnax's attorneys, kind of in the background, on November 15, 2022, in which Ms. Yeats states the DA's office does not agree to relief on Broadnax's subsequent writ claims and providing information regarding creation of the Excel spreadsheet regarding relied on by Broadnax to support his subsequent writ claims. She also clarified the origin of the statement during openings regarding where the rich white folks live, which was from Broadnax's interview provided to the defense and admitted during the testimony of Ellen Goldberg. On November 18th, 2022, Herzog wrote a letter to DA Cruzat, who arguing that the state's timeline for the spreadsheet proves that the state took race into consideration in exercising its peremptory strikes during trial, and asked the DA to reconsider their position regarding Broadnax's claim. So this was kind of like an Adnan Syed. They were thinking the fix was in. And they were very surprised when the DA's office said, wait a minute, no, we're not doing that. A second email was sent, and the email and the letter are longer, but those are the kind of summaries, the high points. On November 30th, 2022, Yeats responded, advising that DA's office continues to oppose Broadnax's claims for release because the Batson arguments are not persuasive and the spreadsheet was created to inform the prosecutor's strikes, since the record in all circumstances indicate that the state exercised peremptory strikes on the complained of jurors based on their disqualifying responses during voir dire. The state had valid non-race-based reasons for its strikes that were not a pretext for discrimination. The state believes that much more goes into the whole Batson analysis than merely what appears on the face of the spreadsheet. She goes on to say, we have considered that we know the prosecutors involved in this trial personally and have worked with them. They have practiced before Judge Cruzat and Judge Bolito when they were on their benches. And that the handwritten notes on the yellow pad attached to Herzog's letter as Exhibit 3 were made during the direct appeal by an appellate ADA preparing to defend against Broadnax's claims. The notes were made years after trial while analyzing the record by someone who did not participate in voir dire. On February 1st, 2023, Broadnax filed his first subsequent application for post-conviction writ of habeas corpus. A notation was issued basically wanting the clerk's office to send the writ to all counsel to assign it a new number. It's kind of a housekeeping thing. Then on February 8, 2023, Broadnax filed an amended first subsequent application for post-conviction writ of habeas corpus. I honestly cannot tell what the difference was between the first and the second, because all the claims were the same. His first claim was that he was entitled to review under Article 11.071, Section 5A1, and relief from his conviction and sentence because newly discovered evidence previously withheld by the district attorney's office established that the state violated Broadnax's Batson rights multiple times during his trial, and citing Batson versus Kentucky. Claim 2, Broadnax is entitled to review under 11.071 5A1 and relief from his death sentence because newly available evidence establishes that his death sentence was based on the presentation of materially false and misleading punishment phase testimony by the state in violation of his due process rights under the Fourth Amendment, and that his right against cruel and unusual punishment under the Eighth Amendment. The supplemental clerk's records were received on February 7th and February 15th by the TCCA. On June 7th, 2023, the TCCA issued a per curiam order stating we've reviewed the amended first subsequent application and find that applicant has failed to satisfy the requirements of Article 11.071, Section 5A. Accordingly, we dismiss the amended first subsequent application as an abuse of the writ without considering the merits of the claims. And then there are several letters because the Texas Attorney General on August 9th, 2023, sent a letter to the Court of Criminal Appeals seeking to have an execution date set because Broadnax's first subsequent writ had been denied. And they stated, while he may still seek certiorari review to the United States Supreme Court, now is an appropriate time for this court to schedule an execution date. And they provided dates, and they were requesting an execution date. Now, this is interesting. The Attorney General's office, I think, was stepping in because they were not seeing any movement or intent on the part of the DA's office to do so. So basically, and in post-conviction, it really is generally the Attorney General's office that handles the post-conviction process in most cases. But the irony in this case is that such a liberal reform DA is not willing to give relief.
Right, exactly.
On August 15th, 2023, Camille Knight, on behalf of Broadnax, sent a letter. First, I respectfully submit that this is not an appropriate time to schedule an execution date in this case. Broadnax's first subsequent application for writ of habeas corpus was dismissed on June 7th, 2023. But the co-counsel had been working diligently on a petition for certiorari to the United States Supreme Court, seeking review of that dismissal. That petition is due to be filed on September 5th and will likely take a number of months to resolve. Broadnax has pursued his application for a writ in a timely and expeditious manner, and we believe his claims to have substantial merit. Second, I note that I do not understand Mr. Marshall to have a role in this matter before the court. The state is represented in this court by the Dallas County District Attorney's Office, not the State Attorney General, and the District Attorney has been actively participating in these proceedings. Indeed, it was the Dallas County District Attorney's Office that filed a motion to dismiss Broadnax's application for a writ before the Court of Criminal Appeals. Mr. Marshall has not appeared for a party in this case, nor has he filed a motion seeking to do so. On August 31st, the Texas Attorney General followed up. Basically, they are still seeking the execution date for Broadnax, providing additional dates because of the Cantu execution, presenting a conflict. And then on September 5th, 2023, Camille Knight sends another letter updating the Court of Criminal Appeals that, or the trial court, rather, that Broadnax's petition had been filed. So the petition was filed. It was assigned docket number 23-248 on September 5th, 2023. The question presented was whether the Texas Court of Criminal Appeals decision that Broadnax failed to establish a prima facie equal protection claim conflicts with this court's Batson jurisprudence. And the reasons for granting were that the court newly discovered evidence establishes multiple Batson violations, and the state court decision, if left to stand, will create perverse incentives for state prosecutors to conceal evidence of Batson violations. The problem with that argument is that the spreadsheet does not prove Batson violations, but they never let the facts get in the way, do they?
This is just throwing spaghetti on the wall and seeing what's sticking, right?
Yeah. So, all right. So then on September 21st, 2023, Herzog sends a letter to the Supreme Court correcting a statement in the petition regarding the date on which a juror questionnaire with notes was provided to Broadnax's counsel. Because, of course, in their pleadings, they act like the state was hiding this stuff, and and trying to prevent Broadnax from pursuing these claims by not timely disclosing. When at the time of trial, they don't have to disclose work product. It's kind of annoying that they've begun disclosing it in the post-conviction process, because then it's taken out of context, as we saw in Glossop. Once it's work product, it should remain work product. If it's work product at the time of trial, it's always going to be work product. Just as a defense attorney is not required to provide his work product to the prosecution. And then NAACP Legal Defense and Educational Fund filed an amicus curiae brief on October 16, 2023, basically arguing that there's powerful new evidence that Broadnax's conviction and sentence of death are tainted by racial discrimination in jury selection, that the insidious harms caused by racially discriminatory peremptory challenges extend beyond individual court proceedings, that racially discriminatory use of peremptory challenges has continued since Batson, and claiming the Dallas County District Attorney's Office has a history of systematically removing Black prospective jurors, and Broadnax presented evidence of racially disparate removal in his case, which is really kind of irresponsible of them, because I don't think they present anything more than that's what we believe.
That's what it sounds like. Well, what's the evidence?
Mm-hmm. Yeah. Because I don't find a single Supreme Court or even District Court, Northern District Court, or Fifth Circuit opinion that says Dallas County has a history of this. The state filed its brief in opposition on November 3rd, 2023. They framed the question presented as, does this court have jurisdiction to review the Texas Court of Criminal Appeals dismissal of the Batson claims raised in Petitioner Broadnax's first subsequent state habeas application, where the state court's dismissal order rested on independent and adequate state law procedural grounds and explicitly stated the court did not reach the merits of the claims. And then they listed multiple reasons for denying the petition, which I'm not gonna go through, because the petition was never granted. And of course, Broadnax filed a reply on November 17th, 2023, arguing that the decision below was based on a substantive federal ground. The court did request the record on December 4th, 2023, and received the record on December 5th, 2023 from the TCCA. And the Broadnax filed a supplemental brief on February 2nd, 2024, seeking to have the case abeyance until Glossop was decided. Basically holding on, not disposing of the case until they decided Glossop. Conference was held on June 20th, 2024, and that was after several prior conferences being rescheduled, beginning in January of 2024. And then on June 24th, 2024, the petition was denied, and Sotomayor and Jackson gave a statement that they would reverse the judgment. So then we go back to the trial court on July 22nd, 2024. The Texas Attorney General advised the court that the petition had been denied, and Broadnax had indicated he intends to file yet another subsequent habeas application. However, there was no basis in the code to delay setting an execution date, and if he filed it and he could seek if he filed something, he could seek a stay. Of course, Camille Knight didn't agree with that, and she basically wrote a letter saying, don't do this just yet. We're going to pursue more claims. which we'll get into later, so I'm not going to go through what they were. And their letters are a lot of just kind of bolstering their claims and repeating the same thing even after a court has dismissed it. So, all right. So then we have the second subsequent. That was assigned that was in Criminal District Court in Dallas County, number 7. Docket number WR082467Y (C). Judge Chika Anyam, and then it also was in the Texas Court of Criminal Appeals, docket number WR81573-03. Broadnax is represented by Camille Knight, Stephen Herzog, Pietro Signoracci, Wenhua Eva Gao, and Jennifer Kim. And everyone, Herzog, Signoracci, Gao, and Kim are all admitted pro hoc vice. The state is represented by Shelley Yeats, Micasha Allen, Christina O'Neill, Edward Marshall, and Stephen Hoffman with the OAG's office. The writ was filed on August 20th, 2024, second supplicant application for writ of habeas corpus pursuant to Texas Code of Criminal Procedure, Article 11071, Claim 1 under the Court of Criminal Appeals recent decision in Hart versus State. Broadnax's due process and fundamental fairness rights were violated at the punishment stage by the admission of rap lyrics as evidence. Under the Supreme Court's recent decision in this Claim 2, Smith versus Arizona, Broadnax's confrontation clause was violated by the admission of Kimberly Mack's forensic report and the testimony of DNA expert James Nichols. Again, another notation of subsequent writ application was issued by the court for handling of the writ. State filed a motion to dismiss Broadnax's second subsequent application at the TCCA on December 11, 2024. Arguing that it should be dismissed because the claims are procedurally barred under Article 11.071, Section 5. Because they were never raised in the trial court. They weren't raised in the trial court at trial. He didn't object to the rap lyrics at trial. And he didn't raise it in his direct appeal. He didn't raise it in his initial post-conviction or subsequent post-conviction. And on December 20th, 2024, Broadnax filed an opposition to the state's motion to dismiss, arguing that the Hart versus State and Smith versus Arizona each provide a new legal basis for habeas corpus relief that was previously unavailable under Section 5A1 of the Texas Code of Criminal Procedure, Article 11.071. At the same time, in his first subsequent writ or application, he filed a suggestion to reconsider on the court's own motion on June 3rd, 2025, arguing that declarations from jurors AL, DM, and CR and jury selection notes from Cummings' case were new evidence of Batson violations. That was disposed of on November 6, 2025, when it was denied without written order. Then again on October 1st, 2025, Stephen Swan's mother, a letter was filed in the court, written by Stephen Swan's mother on August 22nd, 2023, that stated, "It's my understanding that Texas Court of Criminal Appeals recently dismissed James Broadnax's habeas application. I want to ask that you schedule his execution date as soon as possible. Broadnax was sentenced to death for the June 19th, 2008 murder of my son, Stephen Swan. We have waited 15 years since losing Steve in this brutal murder and have been waiting 14 years for this sentence to be carried out, during which time several members of Steve's close family have passed away while waiting. I understand that Edward Marshall, Chief Criminal Appeals Division, has suggested some dates for the execution, which are acceptable to Bobby Lumpkin, Director of the Texas Department of Criminal Justice, Correctional Institutions Division. I want to urge you to schedule the execution of James Broadnax for one of these dates this coming February and help us to find some closure in this very painful loss. Thank you so much for your attention to this matter. The suggestion to reconsider again was denied. I'm sorry, I copied that in the wrong place. On the same date, November 6, 2025, the Court of Criminal Appeals issued an order. We've reviewed the application and find that applicant has failed to satisfy the requirements of 11.071 Section 5A. Accordingly, we dismiss the application as an abuse of the writ without considering the merits of the claims. Camille Knight then sent another letter to the trial court advising them of the dismissal, but that Broadnax intended to file a petition for writ of certiorari, and that requesting that they not set an execution date. On November 14, 2025, the Attorney General sent a letter requesting the execution date be scheduled for January 28th for April 28th, 29th, or 30th of 2026, which are dates available according to Department of Corrections. On November 17th, 2025, Camille Knight wrote again, responding to the letter requesting an execution date, and she reiterates the claims in the second subsequent and first subsequent applications, both of which have been dismissed, and a writ has already been denied on the first dismissal. On the first subsequent application. She also informs the court that they intended to seek relief from the district attorney's conviction integrity unit. And she says, in addition to these court cases, Broadnax is preparing a letter to be filed with the Dallas County District Attorney's Conviction Integrity Unit requesting that the office review his conviction, as well as the convictions of other criminal defendants based on the Dallas County District Attorney's Office attorneys' historical systemic practice of improperly considering race when selecting jurors to serve on criminal trials, as outlined in the first subsequent petition and the suggestion for reconsideration, and as District Attorney John Cruzat has recently acknowledged in public statements and filings, the Dallas County District Attorney's Office had a long historical practice of improperly striking jurors on the basis of their race. We will be requesting that the district attorney investigate those past practices, identify individuals, including Broadnax, whose convictions were obtained in violation of their constitutional rights. This request is consistent with the mandate of the Conviction Integrity Unit, which includes cases involving instances of wrongful conviction when related to an innocence claim, as well as the result of systemic errors. We expect to submit our request to the Conviction Integrity Unit in the next several weeks. And so, again, they're requesting that based on these intended plans, they don't want an execution date set. And I think it's funny because the AG's office has been handling. But after this letter, Dallas County District Attorney taps in on December 11th, 2025, and states on November 17th, 2025, Broadnax's counsel filed a letter with this court in response to the Attorney General's November 14th, 2025 letter proposing that the court set an execution date for Broadnax during the last week of April 2026. The state files this letter to counter several statements or propositions made in Broadnax's letter and to advise the court that the DA's Office Conviction Integrity Unit will not be reviewing this case. Statement: Broadnax rap lyrics had no connection to his crimes. That was in the second subsequent writ. First, counsel advises the court in their letter that they plan to file a petition for certiorari with the U.S. Supreme Court following last month's dismissal by the Court of Criminal Appeals of Broadnax's second subsequent application for writ of habeas corpus, including dismissal of his complaint that punishment phase admission of his written rap lyrics violated his constitutional rights. Problematic for Broadnax and seeking review by the U.S. Supreme Court is that the CCA dismissed his rap music claim because it did not meet the procedural requirements of 11.071 Section 5, meaning the claim was not based on new facts or new law discovered or developed since his last habeas application, as required. Because the CCA dismissed the claim on state law procedural grounds, the chances the U.S. Supreme Court will grant review on an appeal from the CCA is close to zero. Further problematic for Broadnax in seeking review by the U.S. Supreme Court is that Hart versus State, the 2024 Texas case he bases his rap music claim on, is grounded in Texas evidentiary rules, not constitutional rights. Admission of rap lyrics is a mere state law evidentiary issue and is not cognizable as a federal constitutional claim. There is no precedent in which the erroneous admission of rap music evidence has reached the level of a constitutional violation. The state cannot find a court anywhere, state or federal, that has considered a rap music complaint to be a federal constitutional issue, and Broadnax has cited none in his filings. The state takes issues with counsel's statement in the November 17th letter that Broadnax's rap lyrics had no connection to the crimes for which Broadnax was convicted. Simply put, the complained of rap lyrics were in 2 spiral notebooks found with Broadnax's belongings in Stephen Swan's Crown Victoria, the vehicle that Broadnax and his cousin stole to flee from the robbery and double murder scene. This fact alone provides their connection to the murder. The state offered the spiral notebooks along with other writings and drawings primarily to show Broadnax's use of gang terminology and symbols. The references in the materials to violence and crime were collateral. Broadnax had announced his gang affiliations in a recorded media interview, claiming, "I'm a folk." In order to identify language and symbols referencing the folk nation and gangster disciples, Dallas police officer Barrett Nelson testified about Broadnax's recorded media interviews, an audio recorded jail call, items found in Broadnax's Dallas County jail cell, and the spiral notebooks. Based on Broadnax's multiple instances of self-identification in these materials, Nelson concluded Broadnax was a member of the gangster disciples. The rap lyrics in the notebooks, presumably written before the capital murders, reference themes of murder, robbery, and drug sales. In short, while the lyrics may have been Broadnax's artistic creations and expressions, they also had a connection to his crimes and were relevant punishment evidence because they were in the murder victim's stolen vehicle at the time of Broadnax's arrest, and they showed his gang affiliation or interest. And of course, punishment phase evidence need only be relevant to sentencing to be admissible and may include evidence of the defendant's background and character. A photograph of written rap lyrics admitting to the 2 capital murders taken pre-trial in Broadnax's Dallas County jail cell and admitted during the punishment phase of trial demonstrated his extreme lack of remorse for the offense and his stone-cold attitude toward his victims and the judicial process, all relevant to punishment. The lyrics refer to the robbery, murders, and trial in this case. And Kyle, would you like to read the rap lyrics for us to give it a male voice?
Oh, I would love to. I'm going to have to pull them up, though. Give me a second. The chance to read rap lyrics. I mean, how can anyone possibly pass those up?
And I'll take the footnotes.
Okay, sorry. What page is it?
This is 25.
Okay, hold on. Bear with me, guys.
Uh-huh.
Oh no, do I not have the page numbers on this one?
Rick played Broadnax last week, so I'm gonna let you play him this week.
Yeah, my rap lyrics, I'm the whitest kid you know.
Okay, sorry, bear with me. I'll do some my own rap in the interim.
And just so you know, If it has the N word
I'll
spelled
give
out,
us
you don't have to say the N, just say N word.
that. Okay, sorry, pulling it up. This will be worth it though for sure, because
Yeah.
I'm sure he's an amazing rapper. I mean, he's basically got the Snoop Dogg. You said page 25, right?
25 of
Okay.
48. Starts
Oh
with send to
goodness.
press.
Send a press, send a paper, hold up, stop and rewind. That shit. I'm about to tell a little story while I'm about this bitch. Yay, I hit the lick, but the reason I got caught 'cause the N-word snitching shit. Now this bitch ineligible. Me, I got 2 counts of murder. I'm gonna go to trial and tell the judge. I'm going to murk him because I'm JB, bitch. Do you know who you fucking with? Effing
And
murk means kill. Man, that's amazing.
that was the footnote that I was going to take, but
Oh no. Oh, I'm so sorry
yeah,
that I rushed
it's
over your
okay.
footnote.
That's okay. That's all
Man, I
right.
feel like I should, man, I wish I could come up with stuff like this.
It's
Uh-huh.
sent chills down my spine.
Yeah. So, and that directly refers to the murder. So all these claims that it was just his artistic expression, but this directly refers to the murder
I mean, I feel like,
because
with all due
his
respect,
family his family did the right thing and went to police. I was going to say sold him out, but they didn't. They did the right thing and they went to police.
I feel like labeling anything this guy does as artistic is really unfair to artists in the world.
Yeah. Um, all right. So while counsel does not mention admission of this rap lyric in their letter to the court, they do not exclude it from their complaints either. Next statement. A seating chart from Broadnax's co-defendant's capital murder trial that includes a notation of the race of the voir dire panelists provides newly available evidence of prosecution's practices in violation of Batson and Broadnax's trial. The district attorney states second, counsel advises the court in their letter that they plan to file further litigation following the Court of Criminal Appeals denial last month of Broadnax's request for reconsideration of his Batson claims. The request for reconsideration was based primarily on a voir dire seating chart in the district attorney's trial file for Broadnax's co-defendant, Demarius Cummings, which noted the race of each panelist. But Broadnax neglects to tell this court in his letter that Cummings' jury was composed of 6 white, 4 black, and 2 Hispanic individuals. Additionally, the case records show that each side exercised 10 strikes, although there is no documentation breaking down the strikes by party. Of the total 20 individuals who were struck, 16 were white, 2 black, 1 Hispanic, and 1 Asian. These numbers by themselves show that not even prima facie evidence of race discrimination existed in Cummings' trial. The seating chart for Cummings' case is not illustrative of purposeful race discrimination in his trial, much less in Broadnax's trial.
Yeah, this is going to be a lot like all the disinformation around the Austin Metcalf murder, where the race hustlers are saying it was an all-white jury, when in fact I think there was like half white, half, minorities. There just weren't any African
It,
Americans, but that doesn't mean it's all white.
Right, exactly. I think it was 7 white, and then the alternates were, and it was more than 12 because they had alternates. So it was 7 white, and then Asian, Hispanic, and a Middle Eastern or South Asian, because they alternately described her as like Indian or Pakistani, which is South Asian,
Hmm.
or but I think they also had Asian, like Chinese,
Right.
Japanese. Um,
Yeah, yeah, that's
um,
another rabbit to chase. I don't understand this new South Asian term, like they're Indian. Like, I feel like
yeah,
that's a term
well,
that was very easy to
they're,
understand.
I think part of the problem is that Afghan, Pakistani, and Indian have for years been lumped in with Middle Eastern and believed to be Middle Eastern, and they're not. They never were. So I think the attempt is, as making sure people know they are from South Asia,
Oh, fair.
not the Middle East.
Gotcha.
Perhaps they probably thought because they're Muslim, but I mean there are a lot of Muslims in Southeast Asia,
Right.
in Indonesia,
Like, yeah, I think Indonesia's like, isn't Indonesia like one of the largest Muslim
hmm
countries? I think
and the
actually.
Philippines, I think, as well.
All right.
So yeah, but it is, like I said, it's the once the direct appeal is over with Carmela Anthony, that's going to be like the first case. As soon as that direct appeal opinion comes out, that's going to be the first case.
Right.
So I'm gonna get into that case, because the abuse of the Metcalf family by his supporters is just, it's disgusting.
Yes.
They're bullies.
Yep.
And then they try and claim that anybody who thinks Carmelo Anthony is guilty is the bully.
Right.
So, but we'll go into that, because that one is very very racially explosive.
Right. And
Because the Anthonys made it.
Yes.
Yeah, the Anthonys made it that way.
Yeah,
from
they
day
were trying
one.
to run an OJ.
Yeah. So the DA's letter goes on to say counsel is grasping at straws. The state exercised peremptory strikes in Broadnax's case on the minority jurors based on their responses on the written questionnaire and during individual voir dire, not based on race. Over the years, every state and federal court has found the state strikes in this case to be non-race based, and as Batson claims, to be meritless. During jury selection, the state struck 7 black veneer members. Of these individuals, 6 of them indicated during voir dire that either they were not in favor of the death penalty or it should not be invoked. It is indisputable under Texas and federal law that opposition to the death penalty is an acceptable race-neutral reason for a strike. The 7th juror, AL, indicated on her questionnaire that she would automatically be prevented from assessing a death sentence if the defendant was on drugs at the time of the offense, a fact relevant to Broadnax. Besides Batson, Broadnax's Batson claims have been rejected by the following courts on dates spanning more than a decade: Criminal District Number 7 in 2009 during trial, Texas Court of Criminal Appeals 2011 direct appeal, U.S. Supreme Court 2012 on direct appeal, U.S. District Court, Northern District of Texas, 2019, federal habeas, 5th Circuit, 2021, federal habeas, U.S. Supreme Court, 2022, federal habeas, Texas Court of Criminal Appeals, 2023, first subsequent state writ, Texas Court of Criminal Appeals, 2025, request to reconsider first subsequent state writ. Third, counsel advises the court in their letter that they will ask for review by the District Attorney's Conviction Integrity Unit. DA John Cruzot has met with Broadnax's counsel in person, has reviewed and investigated the Batson claim, and will consider and respond to any additional filed litigation. There is no plan nor expectation, however, for the Conviction Integrity Unit to participate in review of the case. On December 17, 2025, the trial court issued an execution order. It is hereby ordered by this court that you, James Garfield Broadnax, having been adjudged guilty of capital murder and having been assessed punishment at death in accordance with the findings of the jury and the judgment of this court, shall at some time after the hour of 6 p.m. on the 30th of April, 2026, be put to death by an executioner designated by the Director of Correctional Institution Division of the Texas Department of Criminal Justice, who shall cause a substance or substances in a lethal quantity to be intravenously injected into your body sufficient to cause your death, and until your death, such execution procedure to be determined and supervised by the said Director of the Correctional Institution Division of the Texas Department of Criminal Justice. On that same date, Camille Knight sent yet another letter to the court, again reiterating that they're going to pursue writs to the U.S. Supreme Court, and that they still plan to seek the review by the Conviction Integrity Unit of the Batson claims. She states Broadnax's claims have substantial merit and have not been fully resolved, and he is proceeding to litigate those claims expeditiously. We again respectfully request that the court not take any action towards setting an execution date for Broadnax before these proceedings have been resolved. On December 18, 2025, a letter from Stephen Swan's sister Deborah was filed into the record. That letter was dated November 26, 2025. She writes, I have written to you in the past to request that you set an execution date for the self-confessed killer James Broadnax, who murdered my brother Stephen Swan and his friend Matthew Butler over 17 years ago, back on June 19, 2008. Earlier this month, the Court of Criminal Appeals denied Broadnax's second subsequent writ and his request to reconsider his jury selection claims, which have been repeatedly struck down at all levels of the justice system. Upon your request, the Texas Attorney General's office submitted to you new proposed execution dates. I would like to respectfully ask that you move forward with signing the order and setting a date. I believe that all of the defense attorney's attempts to prolong Broadnax's life serve only to waste the time and resources of the courts and taxpayers. In particular, I feel his lawyer's intent to submit a request for review by the Dallas County District Attorney's Conviction Integrity Unit is ludicrous. The Conviction Integrity Unit in Dallas County was the first of its kind in the nation and was established by former DA Craig Watkins soon after he took office in 2007. DA Watkins met with my family on multiple occasions leading up to both Broadnax's trial and that of his co-defendant Cummings. I remember DA Watkins telling us about the Conviction Integrity Unit, displaying a sense of accomplishment in what this division had achieved by exonerating those wrongfully or unfairly convicted in the past. I sat in a room with him on multiple occasions and can say with confidence that I believe his personal involvement in Broadnax's case removes all shadow of a doubt in my mind that any unfair advantage was given to the prosecution. He was very attentive and seemed to care a great deal that trials conducted in Dallas County during his tenure would be fair in all aspects, including jury selection, pressing suitable charges, and seeking appropriate sentencing, both to victims and to defendants. I feel very confident the review will show that jury selection for this trial was above board. As I have also stated, further delay in this matter continues to inflict harm on the victims' families. I have followed every detail of this case since the day my brother died. Since the first layer of appeals concluded, I have kept the parents of both victims, along with my younger brother, informed as I learn there is movement in the case or as pertinent information comes up. We are all ready for the cloud to lift and for us to be able to put the legal proceedings behind us. Every piece of worthless litigation filed by the defense is another insult and another injury to us, and I have no doubt at this point that the defense will continue to inform you that now is not an appropriate time to set an execution date as long as they have breath in their lungs. There is no end to what they will come up with or try to put a new spin on. And to me, having been present for every minute of the original trial, their arguments are drifting further from truth and rationality. Please sign the execution order and enforce the justice prescribed by a jury of peers 16 years ago on August 21st, 2009. So the Supreme Court writs were filed on the suggestion to reconsider the first state writ. That was a day of execution was filed under 25A99 on February 4th, 2026, arguing that Broadnax was likely to succeed on the merits, he'd be irreparably harmed, and the balance of equities and public interest justify a stay. He also filed his petition for writ, and that was assigned docket number 25-938, and that was also filed on the 4th of February 2026. The question presented was whether the state's considering race as a basis for striking prospective jurors, shown by its listing prospective jurors by race on a spreadsheet used during jury selection, and now confirmed by newly disclosed evidence of similar notations on a chart used during jury selection at petitioner's co-defendant's trial, and by newly obtained affidavits from 3 struck prospective black jurors, violated the Equal Protection Clause of the 14th Amendment under Batson versus Kentucky. Now, this is interesting. They're still trying to rely on Cummings information, even though the letter from the DA to the court 2 months ago says no. That there was no allegation. There can be no allegation of racial discrimination under Batson at Cummings's trial. So, this is another example of the defense just making the claims, even though they know they're not accurate, shading the truth. Are y'all still here?
Oh, no, we're here. We're here. Yeah, I mean, it's interesting just because, like I said, there's no evidence to what they're claiming, but it's just like a parrot. They just keep saying it and saying it, even though it is proven that is not the case.
Yeah. All right. So, and then the reasons for granting the petition, again, I think I'm going to skip that because the petition wasn't granted, but they just argue the newly available evidence from Cummings's trial and the affidavits of the jurors are why they should grant. And of course, the NAACP's Legal Defense and Educational Fund filed a second amicus brief on March 9th, 2026, again making the allegation that the Dallas County DA's office has a history of discrimination, and that arguing that the insidious harms caused by racially discriminatory peremptory challenges extend beyond individual court proceedings, and the racially discriminatory use of peremptory challenges has continued since Batson. The brief in opposition was filed on March 25th, 2026. The questions framed by the prosecution were whether the court has jurisdiction to consider the Court of Criminal Appeals postcard denial without a written order of Broadnax's request that the lower court reconsider on its own motion the Batson claims for his first subsequent state habeas application. Is the court's review warranted when this is Broadnax's fourth petition for certiorari review of his Batson claims, and this court has already rejected the bulk of the arguments Broadnax repeats here? Whether jury selection evidence from Broadnax's co-defendant's trial, where the jury was composed of 6 white, 4 black, and 2 Hispanic individuals, is relevant and supports Broadnax's Batson claims. Whether declarations from 3 excluded black veneer members obtained 16 years after trial, stating they would have been fair and impartial jurors, is relevant to the Batson analysis. And they also argued reasons for denying the petition are the court lacks jurisdiction and the Broadnax's Batson claims are meritless. Broadnax, of course, filed a reply on April 8, 2026, arguing that his Batson claims present an important federal constitutional issue warranting review and that the court has jurisdiction. Respondent also filed a petition a brief in opposition to the motion for stay of execution on April 13th, 2026. The application should be not denied because he's unlikely to succeed on the merits, and he will not be irreparably injured absent a stay, and the state and the public have a strong interest in seeing the court judgment carried out. I'm not going into all the reasons that he wouldn't be successful on the merits. Broadnax filed a reply on April 20th, 2026, reiterating his arguments regarding the new evidence, and a conference was held on April 24th, 2026, and an order was issued on April 27th, 2026, denying that petition. On the same date, a second petition on the second subsequent application was filed, and that was docket number 25A900. again seeking a stay of execution. 25-939 was the number assigned to the petition, and that was also filed on the 4th of February. The questions presented were whether the state's use in a capital sentencing proceeding of rap lyrics composed by a black defendant to argue to a nearly all-white jury that the black defendant must be a violent and dangerous person because he wrote the rap lyrics violates due process, fundamental fairness, and equal protection under the 8th and 14th Amendments to the U.S. Constitution, whether the state's introduction of a state-employed and out-of-court expert's serology report and findings at trial via the testimony of another expert who testified to and relied upon the absent expert's out-of-court statements as a basis of the second expert's own findings violates the Sixth Amendment to the United States Constitution under Smith versus Arizona. They argued the TCCA erred in failing to follow the court's longstanding guidance, including most recently in Andrew versus White regarding Broadnax's right to due process, fundamental fairness, and equal protection under the 8th and 14th Amendments against the reuse of racially inflammatory and prejudicial evidence in the form of rap lyrics. The TCCA erred in failing to follow this court's recent guidance in Smith versus Arizona on the Confrontation Clause claim, and the court has jurisdiction to review both questions. Travis Scott, Eric Nielsen, Michael Render, aka Killer Mike, and Howard Law Criminal Justice Clinic, and other music scholars, artists, and artist organizations each filed amicus briefs in support of Broadnax on March 9th, 2026. And one of the most ridiculous arguments, and I think Broadnax's attorney made it in one of the letters. This is a ridiculous argument. The absence of Broadnax's lyrics from the guilt-innocence phase is an admission of their lack of relevance to the facts of the case. And this is so, the attorney who made this argument should basically ask his law school for all of his money back.
Yeah.
Because guilt phase and punishment phase are different things. And evidentiary rules are different. Yes, they can't use the rap lyrics in the guilt phase because they're more prejudicial than probative. But they can use them in the punishment phase because the prejudicial and probative landscape changes. And the purpose, you can't use the rap lyrics to prove that he committed the murders, even though one of them refers to the murders. But you can use it as evidence of future dangerousness. They also argued that the state used Broadnax's artistic expression to stoke racial and anti-rap bias, that the state weaponized cultural expressions common to rap to improperly portray Broadnax as dangerous and threatening, and that there's a judicial and legislative trend toward prohibiting the use of rap lyrics as criminal evidence, although I don't think that's a judicial and legislative trend in articles, but not in actual legislation or court cases. The state filed a brief in opposition, and basically they argued that the punishment phase admission of Broadnax's rap lyrics during his capital murder trial, including a rap lyric admitting to the capital murder, violated the 8th and the questions presented as framed by the state. Let me go back and start over again. Whether the state court's dismissal of 2 habeas claims based on state law procedural grounds and explicitly not reaching the merits of the claims relied on an adequate and independent state procedural ground that forecloses certiorari review, whether the punishment phase admission of Broadnax's written rap lyrics during his capital murder trial, including a rap lyric admitting to the capital murder, violated his 8th and 14th Amendments under Hart versus State and warrants this court's review whether the admission, without objection by Broadnax, of a serologist's findings and report during a DNA analyst testimony violated his confrontation rights under Smith versus Arizona and warrants this court review. And basically, they argued the state law grounds for denying review were adequate and independent. The rap evidence claim was barred below on state law procedural grounds. And they went into, background fact of the rap lyrics, and that was subject to dismissal on adequate and independent state law grounds. And then the serology evidence claim, which Broadnax didn't challenge at trial, was based on adequate state law grounds. Broadnax filed a reply, and of course he didn't agree with any of that. The respondent filed a brief in opposition to the stay of execution on April 13th, 2026. And again, suggesting that it should be denied because the claims in this writ didn't warrant review. Broadnax filed a reply in support of his request for stay of execution on April 20th. On April 24th, conference was held, and again on April 27th, that petition was denied. And now we go to the last gasp, and that is in the Criminal District Court of Number 7 of Dallas County, Texas. I wish all of your courts were consistent in how they style themselves, Kyle. Could you do something about that for me?
We're just trying to find the ability to elect DAs that aren't criminals and that are actually literate. Like, you got to research on your own time the new DAs that just be Cruzon. Like, she is like a piece of work. So we're just trying to get literate prosecutors, much less rename the courts.
Okay, well, all right. It's so confusing because, like, in Bastrop and some of these other counties, it's consistent, and then you get Dallas, and it's like number 1, number 7, number 8, and Houston's I think is confusing. Harris County is confusing. All right, so that's my gripe. Same Judge Chica Anyam. Texas Court of Criminal Appeals docket number was WR-81573-04. Attorneys were Camille Knight, Stephen Herzog, Pietro Signorecci, and Eva Wenwa Gao. And then Shelley Yeats for the state. A declaration was signed on March 11th, 2026 by Demarius Cummings, in which he declared, but he did not swear, it was not an affidavit, so it was not sworn or notarized, that on June 19th, I participated in a robbery in Dallas with my cousin, James Broadnax. Well, the robbery wasn't in Dallas, it was in Garland. So could somebody make a list of mistakes? During the course of the robbery, the 2 victims, Stephen Swan and Matthew Butler, were shot and killed. In 2011, I was convicted of capital murder and sentenced to life in prison for this crime. At the time we committed these crimes, I had previously committed and been convicted of other crimes, including burglaries. My cousin James was 19 years old and did not have a criminal record except for a marijuana possession conviction. It was my idea to rob Mr. Swan and Mr. Butler, and I obtained the pistol we took with us that evening and which was used to shoot the victims. Following the crime, James and I spoke about the story we would tell. At the time, we were both still high on PCP and marijuana. I persuaded James to take the blame for shooting the 2 victims. Later, we both gave statements to the media. In James's statements, he said that he had participated in the robberies and shot the 2 victims, while in my statements, I said that while I participated in the robberies, James had shot the 2 victims. These statements were not accurate. In fact, I was the one who shot the 2 victims, not James. This is confirmed by the fact that my DNA, not James's DNA, was found on the pistol. Well, that's not necessarily true because a swab of the trigger found both Cummings, or a mixture of Cummings and Broadnax's DNA. So, I think the DNA they were referring to was on the grip. But DNA, I'm just going to debunk it right now. DNA doesn't tell you who fired the pistol. DNA tells you who handled the pistol. And if Cummings handled the pistol after Broadnax used it, then it's logical that Cummings' DNA is going to be what's found.
Makes sense.
I've met with James's lawyer, Stephen Herzog, several times over the past 10 years until our meeting on February 20th, 2026. I have always maintained that James was the one who shot Mr. Swan and Mr. Butler, but the fact that James received a death sentence for these crimes while I was the one who shot the victims has been weighing on my conscience, particularly as I have become more spiritual during my years in prison. Okay, so he's been sentenced to death since 2009, but it's only on February 20th, 2026 that Cummings decides to come clean. When Mr. Herzog told me on February 20th that James was scheduled to be executed on April 30th, 2026, I decided it was time to come clean, and I told him that it was me and not James who had shot the two victims. I am signing this declaration so that the real truth about what happened on June 19, 2008 is known. My hope is that James will not be executed for committing acts that he did not do. I want to clear my conscience and do not want James to be executed for shooting two people when I was the one who committed those acts. It was my decision to come clean with the facts set forth above and sign this declaration. My name is Demarius Cummings. My date of birth is November 11, 1988, and my inmate identifying number is 016-95832. I am currently incarcerated in the Cofield Unit, Tennessee Colony, Anderson County, Texas, 75884. I declare under penalty of perjury that the foregoing is true and correct.
What a crock. What a crock.
I know, it is, because he's known, because Broadnax went to trial before he did, so he's known he got a death sentence since 2009. But it's just now, because he's got an execution date, that you're going to, quote, come clean. I call bullshit.
I mean, what great timing. You wait short of 20 years, like 18 years, all of a sudden you're conscious, all this spiritualism that he's going through. And then also on top of it too, let's just rewind. Cummings talking to Broadnax about this, like, hey man, because I have a rap sheet, can you take the rap for the two shootings? And I'll just say that I was there and I guided and instructed you. Sure, buddy, I'll help you out. Like they're virtuous.
Well, it's like, are they that stupid that they thought Broadnax wouldn't get a death sentence, especially after the interviews he gave? Right. And the other problem with this, well, I'm not going to jump that. So anyway, so based on this, Broadnax's counsel filed on March 18th, 2026, in the trial record, a motion to withdraw execution order, arguing this court has discretion to withdraw its execution order based on Broadnax's pending applications for habeas relief, that the court should withdraw the execution order to allow investigation and relief based on the constitutional violations claimed in Broadnax's pending habeas application, which we'll get to shortly. The court should vacate the execution order to allow investigation and relief based on new evidence showing that Broadnax was not the shooter. And the court should vacate the execution date to allow investigation and release based on new evidence of Batson violations, and that the court should vacate the execution date to permit Broadnax to seek relief for violations of the 6th, 8th, and 14th Amendments to the U.S. Constitution asserted in the habeas petitions now on writs of certiorari before the U.S. Supreme Court. On the 19th of March, he filed his third subsequent application for post-conviction writ of habeas corpus. Claim 1, Broadnax's rights under the 8th and 14th Amendments were violated because the state secured his conviction and death penalty relying on false evidence. And this one angers me to no end, because You and Cummings decided to lie. How is that on the fault of the state? There's no information or evidence that the state knew about your little deal. Right?
Mm-hmm.
So the state was relying on evidence that, for all intents and purposes, and everything it knew was true. Claim 2, because Broadnax did not commit the capital murder with which he was charged, his conviction violated his due process rights under the 14th Amendment. Claim 3, Broadnax was not eligible for the death penalty and his death sentence violated his rights under the 8th and 14th Amendments. Claim 4, Broadnax's death sentence violated the 8th Amendment because he neither killed nor exhibited reckless indifference to human life. Claim 5, previously unavailable evidence clearly establishes that the state violated Broadnax's Batson rights at trial. So they're going to continue beating that dead horse. He also filed a stay of execution in the Texas Court of Criminal Appeals under docket number WR-8157304. Unfortunately, that one isn't available, so I couldn't see what he said in that one, although I imagine it's similar to the trial court motion. The notation of subsequent writ, a notation was filed on the 23rd of March, and then it was amended on the 26th of March. I'm not quite sure what the differences were. Maybe the court just didn't think it had filed one. I don't know. The clerk record was received by the Court of Criminal Appeals on April 2nd, 2026. On April 7th, 2026, the Court of Criminal Appeals entered an order. We have reviewed the application and find that applicant has failed to show that his allegations satisfy the requirements of Article 11.071, Section 5. Accordingly, we dismiss the application as an abuse of the writ without reviewing the merits of his claims. We deny applicant's motion for stay of execution. And Judge Parker filed a concurrence in which he was joined by Judge Finley. And he said, applicant's claim that he lied when he confessed must fail. He hasn't recanted his confession. His own lies, if that's what they are, do not give rise to a due process violation. He is not actually innocent or innocent of the death penalty, and his claims are barred because they do not fall within an exception to the subsequent application prohibition. I concur in the court's decision to dismiss his application under Section 5. And so then he filed another application for stay of execution at the U.S. Supreme Court on April 20th, 2026, under docket number 25A1158. And on the same date, he filed a petition for writ of certiorari 25-1198 on April 20th, 2026. The questions presented were where a defendant was convicted and sentenced to death for shooting and killing 2 victims without a finding of reckless indifference to human life under Tyson versus Arizona, whether new previously unavailable evidence from his co-defendant recanting his previous statements and declaring under penalty of perjury that he and not the defendant shot and killed the 2 victims entitles the defendant to relief under the 8th Amendment, whether the state's racially discriminatory strikes of all 7 qualified prospective black jurors shown by it identifying prospective jurors by race on a spreadsheet used during jury selection by a notation that its only concern about a juror was his age, race, by newly disclosed evidence of notations of race on a chart used during jury selection at the co-defendant's trial, and by newly obtained affidavits from 3 struck prospective black jurors, violated the Equal Protection Clause of the 14th Amendment under Batson versus Kentucky. And I'm not going to go into the reasons for granting. The respondent's brief in opposition was filed, and they basically framed the questions a little bit differently, whether the state court's disposition, which relied upon an adequate and independent state procedural ground, forecloses certiorari review and a stay of execution, whether the court should review Broadnax's jurisdictionally barred claim that a new jury must evaluate whether he has the requisite culpability for the death penalty in light of highly questionable new evidence from his accomplice when Broadnax never objected to the lack of appropriate parties and anti-parties instruction at trial, despite knowing about his purportedly new facts, when his claim is barred by the invited error doctrine and non-retroactivity principles, and when Broadnax consistently, repeatedly, and profanely admitted in media interviews to being the trigger man. Whether the court should expand its limited resources reviewing Broadnax's latest rehashing of his jurisdictionally barred and meritless Batson versus Kentucky claim after numerous previous iterations have been rejected by the state and federal courts. And basically, Tyson is where, and then there's anti-party and party. So basically, Broadnax is saying, well, I didn't really kill him. Cummings did. So they should have had, the jury should have had an anti-parties instruction that says if I didn't pull the trigger, I'm not eligible for the death penalty. That's also under Tyson. And but he knew when he did the interviews that he was lying, if he was lying. So they don't think the writ should be granted. Reply brief for the petitioner was filed on April 28, 2026, and of course, doesn't agree. The argument is he was sentenced to death without the necessary showing for a non-shooter under Tyson versus Arizona, and arguing new evidence of Batson violations, and that the court has jurisdiction and to review the claims and stay his execution. On April 30th, 2026, that petition was denied. The stay of execution was also denied on the same date, or all of his stays of execution were denied on the same date. I don't know if I have them on the list or not. So now we go into the clemency process. On April 2nd, 2026, one of the jurors in his case, her name is Edith Clemens, but she appears in some interviews and some letters as Elaine, which is really strange. And Edith Clemens is the name of a federal appellate court judge. So it gets very confusing trying to find information about her. She says, I am Edith Clemens, and I served on the jury that sentenced James Broadnax to death approximately 17 years ago. When I was interviewed as a prospective juror and asked if I could be able to issue a death sentence as a crime fit the punishment, I knew it was going to be a terrible burden, but I felt I had a responsibility to serve my civic duty as juror and said yes, as I was confident that I would be honest and truthful and careful to watch every detail. The trial was carried out, and it seemed to be an open and shut case after the video of the interview of James from the jailhouse seeming to brag about shooting both Stephen Swan and Matthew Butler. In that video, James confessed that he was the shooter of both men. The only defense presented that I can recall was his aunt, who talked about how bad an upbringing James had as a young child. I didn't take lightly having to sentence a man to death. Recently, I have heard news that his cousin, Demarius Cummings, now has confessed that he was the shooter and not James. This information most certainly would have meant a totally different outcome for James. If it's true, I would not have sentenced James to death if the media had not presented the false evidence of James being the shooter. So Broadnax says it's the prosecution's fault. She says it's the media's fault. James's death is now real and very near. This has led me to want to visit James and to want to get a sense of who he really is, as he did not say a word in his own defense at the trial, but we only saw the crazy ranting jailhouse interview. The longer I reflected on that jailhouse interview, the more I felt he was just a scared kid trying to look big, bad, and fearless, perhaps for the gang that that the law wasn't going to break him. It was more of an act than truth. I came into contact with the legal team working on James's clemency, and they helped me schedule a visit with James along with his beautiful wife, Tiana. Now, at the time she wrote this letter, Broadnax and Tiana weren't married. They didn't get married till April 14th. So, problem. In addition to believing, In addition to believing the false confession of Demarius Cummings, now she's believing, and the time for Cummings and Broadnax to play that game was at Broadnax's trial. Cummings should have agreed to testify, gotten on the stand, and said, "I killed him. I shot him."
Right.
And then Broadnax could go, if he's acquitted, he could go to Cummings' trial and say, "I shot him," because they can't re-sentence him to death if they don't sentence him to death, or they acquit him.
Mhm.
So yeah.
Then that would be double jeopardy, right?
Mm-hmm.
Yeah.
Right. During that visit, I was amazed at how intelligent James has become, even though he has been in total solitary confinement for 23 hours per day and only seeing daylight 1 hour per day while still in solitary confinement. He has not been in any trouble while during his incarceration. He has taken the time he has had in confinement to educate and better himself. He is better, not bitter. I told him I was sorry for my part in his being on death row. He told me he was not angry at me and he understood the state had a job to do. I cried. I told him that it was my opinion that if he had lived in my home, that he would never have lived behind bars. He was kind and peaceful. He told me that he has become more spiritual and this has helped him to deal with his burdens. I told him I loved him and would do all I could to help halt his execution. Please do not kill this man. He is not the same young kid that everyone has seen on the jailhouse video so many years ago. He has been in solitary confinement since the young age of 19. I beg you to please halt his execution, give his case a new trial, or at the very least, please change his sentence from one of death to life without parole and release him out into the general population so that he may at least hug his wife during visits and converse with other prisoners. On social media, Matthew's mother, Teresa, addressed on about April 2nd, 2026. Sorry, we're getting a
Weather notification.
weather notification, and I can reach one phone, but I can't reach the other one. She said the defense is trying their Hail Mary pass and it's all a lie. Don't believe that the latest fake confession after 17 years is going to change the cold-blooded killer's planned execution date. Broadnax filed a petition for clemency or commutation of sentence to a lesser penalty or in the alternative a 180-day reprieve and request for an interview and hearing on the matter on April 8, 2026. He argued that his death sentence rests on the false theory that he was the shooter. Newly surfaced evidence confirms that Broadnax was not the shooter. Broadnax should never have been sentenced to death as a non-shooter. A commutation is an appropriate failsafe in precisely these circumstances. Broadnax's pursuit of redemption and while incarcerated merits commutation. That he's pursued spiritual transformation, confronted his past, and supported others through the faith-based program. Broadnax's education and stewardship extend beyond the faith-based program and reflect lasting rehabilitation and impact. Broadnax will continue to contribute to his community if his life was spared. Arguing early childhood trauma and youth at the time of the offense serve as mitigating factors, alleging how he was neglected and abused by his mother and his grandmother and mistreated because he was half white. And on April 24th, 2026, juror Edith Clements gave an interview to NBC5 and she expressed doubt about her verdict and sentence. She says, I feel like that everyone always deserves the very last moment of reasonable doubt. She claimed that hearing his cousin had confessed to being the shooter changes everything. She went on to state that introduction of rap lyrics in the punishment phase had no effect on her verdict. On April 28, 2026, there was a decision by the Texas Board of Pardons and Paroles, and they denied clemency in a unanimous decision. On April 29th, the NAACP Legal Defense Fund wrote a letter to Governor Abbott requesting that he exercise his power to grant a 30-day reprieve and it relied on the rejected Batson claims and false testimony claims and cited Cummings' confession and claims that one of Broadnax's jurors now doubts her verdict. Also claims that Matthew's wife, Jamie, harbors no hurt or resentment toward Broadnax. Now, I looked all over the place. Jamie Cole initially expressed forgiveness of Broadnax because that's what she needed to go on with her life and raise her children. She has never said that she doesn't believe he should get the death penalty or that he should get the death penalty. She's never expressed anything regarding the death penalty. And of course, it's interesting. They don't mention Teresa Butler and Jean Swan and Deborah Burkhart, who are each actively supporting the death sentence. On April 29th, 2026, the trial court entered an order denying the motion to withdraw execution order. The court found on April 7th, 2026, the Texas Court of Criminal Appeals dismissed defendant's third subsequent application as abuse of the writ. The Court of Criminal Appeals, which the legislature has made the gatekeeper in capital cases for whether a Section 5 exception is met, has therefore conclusively determined that the threshold requirements of Article 11.071, Section 5A are not satisfied. Because the third subsequent application has been dismissed, no proceedings on that application remain to be conducted in this court or in the Court of Criminal Appeals. The court therefore finds there are no additional proceedings that could be necessary within the meaning of Article 43.141D1 to the extent the motion further relies on petitions for writ of certiorari before the Supreme Court of the United States. Article 43.141D does not enumerate such proceedings as a basis for modification or withdrawal of an execution order. Independent authority to stay execution pending review of these matters rests with the Supreme Court of the United States, not with this court. It is therefore ordered that the motion to withdraw execution order is denied. It is further ordered that the clerk of this court send a copy of the order to defendant's counsel, Camille Knight, and Stephen Herzog, and counsel for the state, Shelley Yeats, and Stephen Hoffman on April 29, 2026. The applications for stay were all denied on April 30th, 2026 by the U.S. Supreme Court. They were each denied. The first two were denied as moot because the petitions had already been dismissed or denied. And then the third one was denied outright. On April 30th, 2026, Broadnax was executed. His final statement: to the family, I prayed for years that any of my choices would create heaviness in your heart and burdens on your spirits, which sounds like he's praying for them to be upset.
Yeah.
I prayed to God for your forgiveness, despite what you think about me. I hope to God that
Yeah,
prayer was
that's
answered.
very strange. I think he probably just misspoke, right?
I don't know. I don't know. But no matter what you think about me, Texas got it wrong. I'm innocent. The facts of my case should speak for itself, period. Let this moment be what finally sparks the revolution that will be televised. None of it was worth it. Queen Emmett, I love you. My promise still stands. It always will. Keep fighting. Stay strong. Keep God first. Never stop believing. I love you forever and a day. I love you, Queen. Peace. I love you, Queen. Peace, love, and light. That's what I stand for. God bless everybody. That's Tiana.
Oh.
And Broadnax was pronounced dead at 6:47 p.m. on April 30th, 2026. And I think his execution started at like 6:20. I couldn't find the exact time, but I know it didn't start at 6 o'clock on the dot because they were still waiting for the U.S. Supreme Court to. But it ended, and she was theatrical and screamed, and
I mean, she is a queen. Apparently, did she bring her crown and scepter?
Yeah, she's English. It's funny though, because she claims to be English and she claims to have a law degree, but I don't know that she's ever read a single appellate opinion regarding this case.
That's
because
hysterical.
she just continued to cite all the things that have been debunked and refuted and found to be totally untrue. So,
Amazing.
and I swear I have seen her name with another death row inmate, but I can't find it.
Either way, she's another murder groupie.
Yeah, a murder groupie, and now she's a widow.
Well, maybe she could marry Damien Eccles.
I think Lori would probably tear her hair out first. Yeah, that's another one. God, then fucking go away. I saw that post on Facebook. I was like, oh my God.
Yeah, he likes to come and go when it's to his benefit.
Yeah. Yeah, if there's payment involved,
Yep.
he'll show up. So, and that I can't wait till those DNA results come out.
Me too. They're going to be interesting one way or the other.
Yeah.
We know what's going to happen though. So spoiler, most of it's going to be inconclusive crap. Also, a lot of people have touched that evidence since, you know, you've had clerks, you've had the defense, you've had investigators, and you see a lot of like photos, like when they're testing things or like measuring things, people don't have gloves on.
Mm-hmm.
So I'm sure some of that stuff is going to come up.
From what I understand, they were retesting a lot of the hairs, and then they were doing MVAC on the shoelaces.
Yeah,
and that's it.
That's basically it. Now, there might be some clothing items, but for the most part, it's things that have been exhaustively tested.
Yeah.
And yeah. And so they know. And so the whole thing is, well, our DNA is not on there, so that must mean we are innocent, hence we should be exonerated. But that's not how it works.
Mm-hmm.
It's a bait and switch. It's smoke and mirrors, and they know that. And their stupid, gullible supporters are going to believe that. The media is going to report it as that.
Yeah.
And I see it like even with the Delphi case. You have people on the news. Did they get it wrong? Did they convict the wrong person? It's like, no, the evidence was clear and concise. And guess what? It was not a DNA case.
Yeah.
At all. I mean, and when I say DNA, I mean as far as like, the nuclear side of DNA.
Right.
Not the other things as
mitochondrial.
far as, yeah. Well, and even that, like nothing, things pop up. Like, for example, with Abby, she had a hair around her hand. And with that hair, it belonged to Libby's older sister, Kelsey. And initially, when you just heard about this mysterious hair, it's like, ooh, and it's like, it wasn't Richard Allen's. Ooh, like that's really, mysterious. And then when you realized it was Kelsey, and the reason why that hair would be there is because she was wearing initially Kelsey's hoodie. And she has long hair. And I used to have long hair. And anyone knows anything about long hair is that stuff gets everywhere.
Yeah.
It just naturally sheds, and that's what it does. And there are some, like what you call far out psychopaths who will sit there and say Kelsey had something to do with it. But most logical people don't. Even those who would believe Richard Allen to be innocent, they stay away from that. But again, they're going to point to all the smoke and mirrors to say that Damien, Jason, and Jesse are innocent. And that's the kind of crap they're going to do.
Yeah.
Yeah, I don't know that much about the Delphi case, but I didn't realize. I was kind of shocked that so many people think that guy's innocent.
Nothing shocks me anymore. Like with the innocence fraud thing, it's just, it almost now seems commonplace for people naturally to just go the other way, whether it's the guy that shot, Kirk or, you have people who believe that Brian Kohberger is innocent. It's just, it's wild.
Yeah.
Wild. So none of it surprises me anymore. This is where we're at now. It's scary, but that's where we're at.
Mm-hmm.
All right.
All right. Well, that's the end of James Broadnax, literally. Demarius Cummings is serving life in prison. He has not filed any state post-conviction or any federal post-conviction claims. And his time to do so has long since passed. So his conviction and sentence are final, and he has never seen the light of day. Because thankfully, Texas had life without parole in 2008.
And like all the the arguments throughout the 18 so years, they were always different kinds of arguments. Whether it was a racist, racist jury or whatever, or the court or the state being racist by not allowing black people on the jury, which is in this case not the issue. Even so, I thought it was a pretty diverse jury group. White people, Latino, and wasn't there an Asian?
That was Cummings.
Cummings, okay.
Yeah, I'm not sure what I think the precise makeup of Broadnax's was white and one Hispanic.
Okay. And even so, it's like, what do you have anything that would assume they were Klan members to make you think that this would be a biased jury? What gives you the what's the evidence here that they were racist simply because he was black?
Or
biracial.
The black veneer members. Well, actually, there was one black juror because the judge put him back on the jury after a successful Batson challenge. So there was one black juror on Broadnax's jury. And I think one Hispanic juror.
And it just takes one to have a hung jury, right? Like if it's not unanimous.
The other black veneer members were challenged because of their stance on the death penalty. Or, there's that I won't sentence them to death if they were on drugs at the time.
So
which he claimed he was, but he never. I mean, the evidence when they were arrested, they weren't on drugs because the Texarkana police said they didn't show any signs of impairment of any kind.
Right.
So
it's
no drugs they weren't in possession of any drugs.
Right. So it's that, and then later because of rap lyrics in the death sentencing phase, and now it's oh no, right when there's a date for execution, all of a sudden Cummings comes out and goes, no, it was actually me.
Yeah.
And no one considers the timing of that.
Yeah. So, if you search James Broadnax's name, all the articles, he was executed even though he didn't kill anybody. That's what the majority of the articles say. Yeah, well, he said he did it. Just because now you're afraid of death, and but like he admitted it. Like he admitted it to a multiple news organizations, and he was unapologetic. And he admitted it to family. Yeah. This was before they were even arrested. He was bragging to the family about it. Right. And that's why his aunt told him to leave.
Yeah, and I didn't bring it up at the beginning, but it's kind of interesting because the public transportation system in Dallas has kind of gotten a lot of pushback. And one of the reasons is because they basically, it's effectively free. Like you're supposed to buy a ticket, but you can just get on for free. And that's one of the reasons a lot of people are pushing back on it, because they argue it just enables criminals to just, travel across town and commit crimes. And a lot of cities are wanting to pull out of it. And it's kind of interesting that's what he said was he and the other guy jumped on the train to go to Garland because that's where the rich white people lived. And it's kind of, I do not recall this case when we started, but it's kind of the paragon of why so many people are kind of pushing back on the Dallas. It's called DART here, why they're kind of pushing back on it, because it seems to be. And I've ridden it with my son, and it's like a rolling homeless shelter. It's actually I'm more scared to get on the Dallas Rapid Transit than I am on the New York or Chicago subways.
Yeah, and one of the problems is they had dicked around in Garland, and it was after midnight, and the train had stopped running. Now, the sad thing is if they had said, dude, we came over here from Dallas and now we can't get back help, they would have driven him to Dallas. They would have driven
Of
from
course they would
Garland to
have.
Dallas
Absolutely.
and dropped him off. They didn't have to kill him,
Totally. Exactly. They were Christians. They would have
you
totally
know.
driven them, probably
And
taken them and given them money.
whatever Matthew had, he would have given.
Absolutely.
Whatever Steve had,
100%.
he would have given.
Absolutely.
That is the really sad part is that, but I mean, that shows what a sociopath Broadnax and Cummings both were.
Yeah.
Because they didn't care
Right.
that these nice guys, I mean, it's midnight. When you walked up, they stopped and talked to you.
Yep.
At midnight. They didn't just hurry up and get in the car and drive away and leave you standing on the street holding your dick in your hand.
Right.
They talked to you, they engaged with you. It's a shame that it had to happen, but he deserved a punishment. And that's the one he deserved because he had no care for their lives. Why shouldn't anybody have a care for? And he didn't have care for his own life.
Right.
He said he was going to kill people if he got life in prison.
That's right.
So, you wanted the death penalty, buddy. You got it. All right. Well, that is, yay, we're done. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien, Kyle Evans, and guest co-host Rick Mullenax. If you like the show and want to know more, you can subscribe to our YouTube channel, find us on Facebook, or follow me on Twitter at O'BrienLN. Kyle and I, and Rick, you're invited too, will return in 2 weeks for episode 10, State of Ohio versus Mackenzie F. Shrilla. On July 31st, 2022, after a night out with Dominic Russo and Davian Flanagan, Mackenzie Shrilla crashed her vehicle into a building in Strongsville, Ohio. Dominic and Davian were killed in the crash. Shrilla was subsequently arrested and charged with multiple crimes arising from the crash, including murder, aggravated murder, and vehicular homicide. She was convicted after a bench trial and sentenced to 2 concurrent terms of 15 years to life. We'll talk about the events leading up to the crash that killed Dominic and Davian, the investigation, Shrilla's arrest and trial, and her unsuccessful state appeals, and the crash, which is a Netflix documentary. Until then, have a great 2 weeks and stay safe.